Hello, thank you for joining today. And today's video will be all about family mediation. So I hope you enjoy it. Now, just as a short introduction, my name is Agata Osińska. I am a solicitor and family mediator at the International Family Law Group. I specialise in family law. So as a solicitor, I deal with separation, divorce, finances, children, and I deal with the same issues as a mediator. To start with, I thought it would be good for us to have a chat about what is family mediation. Now, I think there is quite a bit of confusion about what mediation is, and many people consider it some sort of counselling or getting back together or a way to get back together, and that is not that. Mediation is a process to allow two or more people, participants, to communicate with each other in a way that is better for them. So as a mediator, our role is to facilitate those discussions and facilitate open communication between the participants. The participants can be husband and wife, can be two ex-partners, can be parents to a child or children, but it's not actually that limited. So it can be different family dynamics, and it doesn't need to necessarily be so strict in terms of who's participating. And so often we'll have two participants and a mediator, so a wife, a husband, and a mediator, but sometimes we might have some third parties involved, depending on what the situation might be. In order to engage in mediation, one needs to understand fully what are the key features of mediation. And those are very crucial to understand and important to understand at the outset of mediation before actually engaging in any joint sessions, so that everyone has a full understanding of what the process involves, what you can and cannot do, and what you can and cannot achieve as part of that process. It's just everything to do with managing people's expectations. One of the most important features of mediation is confidentiality. What that means is people that are involved in mediation can rely on the fact that any discussions that they might have as part of mediation are discussions that will not be shared with the outside world. That doesn't stop those participants from discussing what happened in mediation with their lawyers if they need to seek advice. But what it does is stop the lawyers from later on using those discussions as part of a court process to perhaps try to get a better result from their client because they know the bottom line of the other person, for example. The best way to describe this is everything stays between you and the mediator, and nothing can officially be used as part of any other court processes later on. And there are quite strict rules against that. Now, there are exceptions to confidentiality, and I will mention those in a bit, but those are to do with safeguarding and any risk of harm. Another key feature is impartiality. So often I'm asked a question where people are referred to me or where I am asking my clients to perhaps go to mediation. They are worried that if one party is suggesting the mediator and they're providing a name for the mediator, that mediator will be already on that person's side and will therefore not be impartial because they're the ones that are recommending them. Now, that is not the case. So the mediator's role is to be impartial, not to take sides. It's to keep the approach to all the people involved in the process as balanced as it can possibly be. That doesn't mean that they will not acknowledge some statements made in mediation. Obviously, they're there to help, but they need to keep a very watchful eye on staying impartial and not siding with one person in mediation or also not putting their own biases or their own opinions into the mediation arena. The last key feature that I wanted to discuss as part of this section of the presentation is the fact that mediation is voluntary. That means that at any stage during the mediation, you can decide that you no longer want to continue. And it's the same rule in terms of actually engaging in mediation. If you feel that this is not the right process for you, you should not be forced to attend mediation. And that might be for different reasons. Some people just don't think it will achieve what they needed to achieve. Some people might feel vulnerable. Some might feel forced by the other person to attend it. So there are different reasons around it. If during mediation, again, for whatever reason, you decide this is no longer working for me, again, you can decide to opt out and stop mediation. Mediator can also stop mediation at a point if, for example, they think it's no longer serving its purpose, the parties are not making a progress, or if there are some safeguarding concerns, and for that reason, the mediation should not continue. So it is a voluntary process, but in a minute, I will explain why sometimes it might not feel that way. The first step, introduction as such to mediation, will most likely be a call you might be making to a potential mediator, just asking about what is mediation. And that initial call might just be a very a quick one, just for the mediator to lay out how they work, so that you can commit to a proper first initial meeting. That is often referred to as mediation information assessment meeting, or just a first initial meeting. You might have heard mediation information assessment meeting in the context of the court. If you are to make an application to the court in relation to either financial arrangements after divorce or separation, or in relation to children matters, there will be a section in those applications that refers to attending MIAM, Mediation Information Assessment Meeting. There is obligation on the person making the application to try and attend the MIAM, the initial meeting. There are some exceptions to that, of course. For example, if you are a victim of domestic violence and you have evidence of that, you do not need to attend the meeting. There are some other exceptions that there is a list provided within those applications that you can look at. But generally speaking, the applicant, when considering making an application to the court, will be asked to attend a MIAM first, before proceeding to apply to the court. This goes back to me saying that the mediation is a voluntary process. It still is. You're only obliged to attend MIAM, and if after that MIAM meeting, either you or the mediator do not want to proceed for a certain reason, then that's it. You've done your compulsory bit. The mediator will sign off the papers, and you can apply to the court if that's what you wish to do. Whether that's the best thing for you, it will depend on the circumstances. Mediation can be a very useful tool in any sort of family disputes. You will cover quite a bit in the first introduction meeting. When you do it, this doesn't need to be in relation to a court process. It's not that you need to be considering making an application in order to do MIAM. You can do an initial meeting with a mediator at any stage. And actually, it's quite good to do that as early as possible to try and resolve your matters outside of court before even that route is fully considered. The first meeting should normally take between 45 minutes to an hour. It can be remote, it can be in person. That depends on your preference and the availability of your mediator. You should go for someone who is properly trained as a family mediator, and you can find a list of family mediators who are trained on the Family Mediation Council website. In terms of what is covered in that meeting, you can probably already guess that 45 minutes to an hour is a long time. So that first meeting is fully confidential. I know I've mentioned confidentiality already. What I mean here, though, is that if then after that first meeting you decide to go ahead with joint meetings, you decide to actually mediate, engage in mediation, what you've said in that initial meeting, the MIAM meeting, will not be shared with the other person who you're mediating with. So only the mediator will know what you've said, and that will be kept confidential. This is because we want to encourage people to feel free to share information with us, so that as mediators we are able to facilitate progress in mediation. If you don't feel you're able to share things with us at the beginning, it might be quite difficult for us to know what is really happening in the family and how we can best assist. So the questions you might be expecting from a mediator at the first session is questions around just generally what is happening. Why have you decided to engage in this process? What are the reasons for it? And they might ask some informative questions in terms of your details and the details of the other person, details of your relationship, your children if you have any, details of any assets if that's the heart of the dispute. So just to get an idea about your current situation, what you feel concerned about, what your priorities are in terms of what you want to achieve in mediation. So that will be a big chunk of that meeting, just getting to know you. The other part of that meeting is informing you about what mediation is, how it works, what the key features of mediations are that we've already covered to some extent, how mediation would look like, and what it can and cannot assist with. And if it can't assist, if it's quite clear for whatever reason, based on your discussions with the mediator, that this is perhaps not the best avenue for you, what the alternatives are. And that might be many different ones, depending on what you share with the mediator. They will be able to give you some recommendations, some suggestions, some resources, if that is helpful. That first meeting is done with person A first. If after that meeting we as mediators deem it safe to proceed with mediation, and you want to proceed with mediation as the participant, then what would happen next is we would contact the other person and we would invite them into mediation, informing them and allowing them the same opportunity as the first person had to have that confidential first meeting of 45 minutes to an hour, so they can share their view at the current situation, and they can have the same setup of a meeting that the first person was able to have. After that second meeting, the second MIAM, first meeting for the second person, if they also want to engage in mediation, we'll move on to setting up the first joint meeting. Now, before that happens, we will send you some documents and most crucially, what we call an agreement to mediate. Now, agreement to mediate will cover a lot of what we've already covered in the initial meetings in terms of the principles of mediation. What is important, what are the ground rules in terms of the meetings that we will be having. And that agreement will need to be signed by all the participants and the mediator. So everyone commits to the process and commits to those rules. This is mainly to make the space safe for everyone, and so that everyone understands the rules in the same way and feels comfortable as part of the process. And if that is signed, we can then move on to the joint sessions. Whilst we are still in the individual sessions, we will be discussing the setup with both of you individually. We will be discussing what feels comfortable, what is logistically best. There are many considerations to take on depending on your situation. So we'll be asking you about whether you want the meeting to be in person or whether you prefer a remote meeting. And that might change at certain stages of mediation. You might want to, for example, start with a remote meeting for the initial meetings, but then do in-person meetings for joint meetings, or vice versa. For whatever reason, you might want to decide it the other way around. You might want to do what we call shuttle mediation. Shuttle mediation is where you would not want to be in the same room with the other participant. And so we can set it up in separate rooms, be it remote separate rooms or in-person separate rooms, which means that the mediator is the one going between the rooms and you don't really see the other person during the mediation. That can work for some people, especially if they feel vulnerable being with the other person in the same room and maybe hearing them, seeing them. It might be that that is just your preference. And in order to assist you feeling comfortable in the settings, that is how you want to proceed. Now, both of you need to agree to the way you want to proceed with mediation. It's up to you. You have the control of how you want it to be. Sometimes one person is there physically and the other one is attending remotely. That happens. It might be because of the distance to the mediator's office, or it might be that due to work commitments, that's the only way you can do it. So there are different reasons behind it. Some of it might be, emotional readiness to see the person. Some of it might be the fact that if you hear the other person, you will be triggered by what they say, even if it's nothing bad, it's just the way they say it, their voice, that will trigger you, and therefore you would like to avoid that, and you much rather hear from the mediator what the other person is saying than to hear from them directly. That can be quite a useful tool. All of that will be discussed with you in the initial meetings, and then whatever the arrangement is as the agreed one to proceed with will be the setup for at least the first joint meeting, because you can still change your mind after the first joint meeting. It might be that you've made some type of progress and you feel okay, and now I feel a bit more confident to go into a second meeting if a second meeting is needed in a different setup. In terms of the duration of a mediation meeting, it's really up to you. However, normally these joint meetings take around an hour and a half, can be shorter, can be a bit longer. I probably wouldn't recommend longer than 2 hours because everyone gets a bit frazzled and tired and just the focus is not there. So sometimes it's useful to just finish off at a certain point. Obviously, if a certain topic that is very important to you is not finished and we only require a few more minutes to just address it, then we will do that. But equally, we don't want any big points starting towards the end of the session because we don't want to leave you with that burden coming out of the mediation meeting. In terms of how many meetings you might need and what would be the breaks between the meetings, that really depends on what is happening to you and what the circumstances are and what issues are being discussed. So normally there would be between 2 to 3 joint mediation meetings, and there would be a few weeks between each meeting because normally there would be some homework, some decision making, some thinking to be done between those sessions, and that's the reason why there would be some gaps between the meetings. But there are no written rules about that. So if for whatever reason you feel you would need the mediation meeting one after the other, that can happen as long as you are all available. Mediator can set that up. There are mediations that take more than the 3 sessions. Again, it's all about what your situation is about and whether what we're doing is helpful. So no mediation should just continue for the sake of it. If there is no progress being made and we are running in circles, at some point enough is enough, and the mediator should take control and say, we're not making any progress. Perhaps you all need a bit more time, and you want to come back in a few months' time to the mediation, or this is just not the right process for you, and in order to resolve this, you need to engage in different processes. So it very much depends on what the situation is. Some mediation will end in 1 or 2 sessions, and that will be it, because you will resolve all your issues that you wanted to resolve through mediation. And some will take a lot longer and with big gaps in between sessions, because there will be some document gathering, some information gathering to be done between those sessions. Once we have a bit of an idea of what the setup is for the joint meeting, I thought it would be good to discuss what the discussions in mediations can actually be about. There are different topics that we can discuss, and mediation can be very flexible in terms of what you consider your priorities to be and what you want to discuss. So the most common topics will be separation, finances, children, and anything to do with that. So it is quite broad in terms of what we can cover, and every family is so different. So you might have issues in terms of, who should move out first from the property. You might have issues around, how much money should be paid from one to the other after separation, or how to divide the equity of the family home. You might have issues about how to tell your children about the fact that you're separating, or issues around how to divide their time between the new setup, the 2 homes that they will be having. There might be some very specific issues about certain concerns that you might be having, or something that you heard from your children, or something that you heard from a family, a friend, or even your solicitors that you want to discuss in mediation. Throughout all mediation, including the initial meeting, but also the joint sessions, the mediator has the responsibility of continuous screening regarding suitability. So it might be that although mediation was suitable and appropriate at the beginning, there will be something that happened in one of the mediation sessions, or that was said in one of those sessions, that makes it no longer suitable. So, for example, that might be disclosure around an incident that happened between the participants and the risk of harm to the children or to the adults. It might be that for that reason, even though mediation was a suitable choice at the beginning, it cannot continue any longer because of the risks of safety to the participants. It might be that at a certain stage, social services got involved and they will be preparing a report. And for that reason, we would also, very unlikely, we would continue mediation, at least for a period of time until the safeguarding is done by the social services, because we don't want too many specialists being involved at the same time with the family. So there are certain things that might happen during mediation that will deem it unfit to continue. But that's the mediator's role, to keep an eye on that and make sure that mediation continues to be safe for everyone. I wanted to spend a bit more time discussing finances and mediation. So we'll often have separating families or families that are going through divorce coming into mediation because what they want to do is achieve a fair and quick split of the finances without involving the court or without the cost of the court process. First things first, as with the court process, there is a certain expectation of full and frank disclosure. What that means is, as part of the mediation process, if you want to mediate finances, you would need to disclose your financial information to the other party, to the other participant. and to the mediator. There will be some questions around the documents in support of what you say you have, and different mediators approach this differently. So it might be that they will ask for certain documents, or they will ask for certain screenshots, or they will ask you to complete a full Form E, which is a financial disclosure form used by the court. The advantage of using that Form E document is that you obviously, if for whatever reason you're not able to settle the matter through mediation, you then at least have that form completed, and you can utilize that as part of getting advice from your solicitors and then the court process if needed. Now that document, the financial disclosure part of mediation, is considered an open document. What that means is that can be used outside of mediation process. So the discussions that you're having are confidential, but the documents that you're sharing as part of your disclosure are something that can be used later on if needed and can be relied on. So it's important to understand the distinction between those two. It's also important to understand that you need to disclose all your assets. So that includes properties, savings, that can be bank accounts, savings bank accounts, but it can also be shares, crypto assets, or any other assets that you might be having. There will need to be a disclosure of liabilities, any credit cards, any loans that you might have. There will be a disclosure of income, of pensions, and also disclosure of any belongings that are valuable. All of this is quite key in order to start proper discussions, because without knowing what the background is, you and the mediator will find it quite difficult to start having open discussions about what should happen. And the mediator's role in facilitating your discussions is to also reality check those proposals that you might be making in terms of what you want to achieve, what you propose as a settlement. So without knowing the full background of your finances, it's very difficult to then say, is this affordable? Is this realistic? Is it something that the court would consider fair and reasonable? Sometimes the finances are so complicated, or the participants are so far apart or on certain issues, that it's important to consider involving some experts' input. And that might be pension experts, for example. Pension assets are quite an important part of any negotiations in terms of division of finances on divorce. And they're a very complicated asset. A mediator or a solicitor cannot advise you properly how those assets should be divided. And mediator will tell you that the court will have some questions if people don't understand their pensions fully, or they haven't addressed them in any settlement. So a pension expert might be one person that you want to ask for a report. You can utilize mediation, or for example, you might want to have a accountant involved in your mediation to prepare a report about either your tax liability, potential tax liability on your assets, or, for example, they might need to prepare a report about a company that you're a director of. So there are certain assets that might require a bit more information to be provided in order to have a clear picture of what is actually happening with that asset and what is being suggested. But the flexibility of mediation allows for those third parties to be involved, as long as both participants agree that that's the right thing. And those experts then are involved as being impartial, again, providing their answers to specific questions that you might have. That might be done through assistance of lawyers. If you have lawyers involved, if you have solicitors, they might help with that part, or a mediator might help with it, depending on how you want to set it up. Again, there's quite a bit of flexibility here, so it will depend on your situation. Apart from finances, we often discuss, and this is a big part of mediators' work, often discuss children in mediation. So the key part here is to focus on the children's needs and make sure that they are treated as individuals, because their needs will be different depending on their age, depending on who they are as a person, what characteristics differ them from their siblings, if there are siblings. And this can be quite challenging sometimes for the participants to understand, because it's quite easy to overlook sometimes that different children might have different needs. And so mediator's role here is to focus on the children and make sure that the parents do so as well. At the same time, there are many things that a mediator can assist with in terms of children issues. So I've already mentioned before that it can be discussed in mediation how to tell children that you are separating or you're divorcing. Obviously, that means you would need to attend mediation quite early on. More often or not, what we face is the kids already knowing about the separation divorce by the time mediation starts. However, there might still be some topics that you want to agree on how those should be delivered to the kids. Perhaps one of you is moving out of the family home and you want to have a chat about how to deliver that news to the kids, or you need to tell them about something to do with the child arrangements, the nights they will spend with one another or with you. So it is all about that. It's all about assisting you and facilitating those discussions so you find the best solution for your family, because every family is different. It's discussing the term time arrangements and the holidays arrangements, and that can be very flexible if you need it to be, or it can be very specific if that is your wish and your family thrives on, having a schedule and a routine. We would be discussing a parenting plan. So it's not only about the specific arrangements for care, but it's also about how you want to raise your kids and as a co-parenting parent with this new dynamic in place. It can also be about how you want to communicate with each other about your children. What would be the best way to do so? Would you prefer to just continue as you are at the moment with emails and calls and text messages, or would you like something a bit more formal? Maybe some structure in terms of using a parenting app would help. Maybe just an agreement of how to share things between you when they are in the other's care. Things like that are quite important, and there are many small things that people don't think about until they're actually in that situation and they realize, oh gosh, we haven't discussed that. Maybe mediation is the best place to do so. I've mentioned on the slide child inclusive mediation. What that is, this doesn't apply to all the children, but as part of mediation process, you can involve the child in the mediation itself. They're very, in a very particular way. So what would happen is, firstly, the mediator would have a discussion with you whether that's something you want to consider, whether you would want for the mediator to speak to the child about what, about their feelings and how they are, given what is happening. If you both agree and the mediator feels it is appropriate, and for many reasons, it might not be. It might be that your child is too young to be involved in the process and share their opinion. It might be that the mediator, from what you've said, feels that there is not much benefit of involving the child in the mediation. There are different reasons for it, but we certainly don't want to expose children to something that would be harmful to them in any sort of way. So, for example, if there are specialists already involved with the children, again, that might be a red flag and might mean to us that perhaps there is too many people already involved and we don't want to be introduced as one and as another. Child inclusive mediators are trained additionally, so there is additional training for child inclusive mediators separate to the regular mediation training. Normally what would happen is your mediator would introduce a separate child-inclusive mediator, and that mediator, if you both agree that you want the child to be seen, would meet the child separately. Again, that meeting would be confidential, so the mediator would not be able to share with you what the children or the child actually said. What they tend to do is, towards the end of their time with your child, they would ask the child of what message the child does want to pass to you. They would agree what that message is. That is the only thing they would pass to you. So I think there's quite a bit of confusion about, how much the parents can get from involving a child. And it can be very, very helpful. But we also need to be mindful of trust that the children put in the mediator and them wanting to feel safe and make sure that they feel comfortable and safe in the process. Just needs to be caveated in that way and managed properly. But children can be involved in mediations. They're just not involved in the joint sessions. They have their own meeting with the child-inclusive mediator, and thereafter a feedback is passed through the child-inclusive mediator to the parents about what the child has said. But that is only what the child agrees to be passed. So there are occasions where the child will say, I don't want you to say anything to my parents about what you, and they won't be able to. Even if that happens, they might just open up the child a bit more going forward. It might mean that later on, even if it's not in that session, the child will start discussing things with you outside. There's certain rules about you not asking, not pushing, not pressuring the child about what was discussed in mediation itself. So there's quite a bit of rules around that, just to make sure that the children are safe and comfortable in the process. In terms of the age that the children would be involved in mediation, what age do they need to have? Normally we would say around 10 years old, but again, there is no cut-off age as such. So, for example, if there is a child who is 7, but you as parents know that child is very mature and can talk for themselves and has lots of opinions, mediator can still proceed on that basis. If there are groups of children, siblings groups, and one of the children is, let's say, 11 and the other one is 8, you would want to invite both kids, if possible, to mediation. The kids also have a right to say no, they don't want to attend. But it's their choice as well. It's your choice as parents first to agree whether you want to involve them or not. But if they say no, I don't want to be involved, then that's their choice. Coming towards the end of mediation, it is important to understand what are the legal consequences of mediation. So if you had a few sessions, joint sessions, or one session, and you reached some agreement, a compromise, you might think, that's it, I'm done. I have this settlement reached and I can go and be happy and just continue and move forward. Now, I would love to say that's it, but if you want to make it legally binding, there are a few other steps to take. So towards the end of mediation, if you reached compromise, you would be receiving what we call a memorandum of understanding. So a mediator will draft this document setting out what you agreed on and what you discussed. You will also receive open financial disclosure. So this will be a collection of the documents that you shared with each other during mediation. As I said again, the open financial disclosure is a document that is not confidential and can be shared with the court at a later stage if needed. Memorandum of Understanding, however, is a confidential document that can be shared with your lawyers, but not with the court. What that means is if you want to make that agreement a binding agreement and have finality to it, what you would need to do is to go to your lawyers with the Memorandum of Understanding and with the documents that you received from your mediator in order to make it into a consent order in terms of finances. The mediator can also prepare a parenting plan for you. And again, you might want to confirm that in writing between your solicitors, or you might want to have a consent order to do with child arrangements, although the regular principle, if it's not needed, it's a no order principle, and the court will not make an order just for the purpose of making it to do with the children. It's also important to get some advice as part of this whole process. Now, the mediator in mediation can offer you information. They can provide you with information that is easily accessible through other means. What they cannot do, even if there are also solicitors like I am, is to advise you. They're not allowed to provide advice because that would mean, to some extent, that they would no longer be impartial, because in order to give advice, you need to evaluate in the whole case, and it's very difficult to then stay impartial at the same time. So if there is at any point a time when they think you might need advice, and that might be towards the end once you have an agreement, and that is the crucial part, but that might also be during one of the sessions when there is a crucial issue that you're discussing and you're not sure about something, or the mediator can feel that this is a difficult point. They might want to say to you, this is the information I can provide you with, but you might want to consider getting some advice at this stage so you better understand it. And then coming into the next session, you will have the knowledge available to you from the advice that you might obtain. So it is important to get advice and to have lawyers involved, even if you want to focus on resolving your matters in mediation. So we covered quite a bit here, but I wanted to very briefly touch on a few different things. Funding. Is mediation free? Is it something that you need to pay for? Unfortunately, it's not free. It can be for some people if you have access to legal aid funding, although it's quite limited and not many firms do legal aid funding for mediations. There is also what we call a mediation voucher available for £500. Not every mediator does it, but you can utilize the voucher if you meet certain requirements. So it's always important to ask a mediator about the voucher if they offer it. That voucher is available per mediation, so the £500, whether it will allow you to settle through your mediation depends on how much your mediator actually charges for the time and how long you will need. So it might be that the voucher will only fund part of the mediation. You will still need to pay something for some of the sessions, but at least it provides you funds for at least the beginning of it. Different mediators have different rates. Normally, what we tend to do is we tend to have set charges for the initial meetings, which you both pay for yourself if you don't have access to legal aid, so you pay it privately. And then for joint meetings, you're both equally responsible for that fee, but it ends up being cheaper than any lawyer or legal advice, because ends up happening is the mediator charging you a rate and then that being halved because you're only responsible for half of it as joint session. So it can be quite cost effective and a lot cheaper than getting lawyers involved or going to court. Although it is a sensible thing to do, it is not an appropriate approach in all cases. Sometimes it is just not suitable because there is domestic violence, there is power imbalance, people that come to mediation are not emotionally ready, So there are all sorts of things that might mean that mediation is not right for you either right now or at all. There might be some real urgency to address. There are some limitations that what we can do in mediation, how quickly we can do it. So if mediation is not suitable or not the recommended solution, there are other options. There can be negotiations through solicitors. There you can try arbitration. You can try going to court. You can try collaborative law. There are all sorts of different avenues available, and many of them are not really discussed that much because people just think about the court process as the one and only solution. And with the timescales that we have at the moment, you might wait a few months for a court hearing. That's just the first court hearing. You might wait years for a final solution to your case. So it is important to consider those alternatives and to see what is the most appropriate to you. The mediator can give you a bit more information about all these other solutions available, and they should do so in the initial meeting that they have with you. They might not cover them all because they might not think that all of them are right for you, or they might just focus on one or two more than the others because of what you say or the circumstances of your particular situation. What mediators should also do, and this can be at the beginning in the initial session, but it can be throughout depending on what is happening, is consider any support that you might need throughout this process. So it might be support through your GP or other charitable organizations or counseling therapy. Going through a family breakdown is such a difficult and emotional time, that it often is very important to have friends and family support, but also support from professionals. So the mediator can make some resources available to you if they feel that that would be of use to you. I touched on emotional readiness already, but what can happen in some cases is that one person has already moved on and is very much ready to discuss finalizing everything and just getting on with their life, whereas the other person might be at the beginning of their grieving and they might be in complete denial. So person's readiness to engage in mediation is also quite important, because if one person is in the denial stage and the other one is in acceptance stage, it would be very tricky for them to be able to successfully mediate and have discussions that are meaningful, because they will be coming at it from completely different points of view. So sometimes it might be that they will need a bit of help from the mediator, but sometimes it will just mean it's not the right time. And the mediator might say, come back when you're both ready, come back in a few months, because what's the point of us just pushing for it if someone is not ready? And finally, just wanted to touch on signposting and providing information. Don't feel like you cannot ask your mediator questions. They should be able to provide you with some information. Again, they can't advise you, but they can provide you with some information and some resources. And as mediator or also a solicitor, if they are one as well, they will have access to some very handy resources that can help you understand where you are, what you can do, what rights you have. So even if that's just some starting information, just to give you an idea, that might be helpful to assist you with understanding how to proceed later on. Right, I hope I covered it all. I'm sure there will be lots of questions and that not everything has been answered by just watching this video. So if you have any questions, please feel free to contact me. I would be more than happy to answer. Mediation can be such a great tool to resolve disputes of a family and to allow them to communicate better for the future. And I would love if more people got engaged in mediation, understood the process and how it can help them. Thank you so much.